everybody, and welcome. We apologize for the delay. Not an unusual tech issue this morning. We really apologize for getting started late. First, I'd like to ask everyone to mute yourselves, turn your cameras on if you have them off, and switch your view from gallery to speaker. If you're not sure how to do that, the team will add some directions in the chat box. So good morning again, and welcome to What You Need to Know About Wage and Hour, DOL Audits, and NJBIA HR program, brought to you by Association Member Trust, Connell, Foley, Focus New Jersey Business Magazine, New Jersey Manufacturers Insurance Group, and NJBIA HR Support Center. I'm Alice Gens, and I'm the Chief Operating Officer and CFO at NJBIA. And today with us is Marianne Tolomeo from Connell Foley. Before we get started, we'd like to show you a quick video on some of the things NJBIA has been working on recently. For those of you who are new to NJBIA, we are the largest statewide business association in the country, representing approximately 1 million jobs in the state of New Jersey, which amounts to about 1/4 of New Jersey's total workforce, offering customer development opportunities, visibility through events, magazine ads, or our podcast and TV show, and money-saving discounts on things you're probably already paying for, like payroll, healthcare, 401k solution, and HR support. Bear with me.
Okay. Good morning, everybody. I'm very sorry for the delay. There were some technical problems with my computer. We're going to be talking today about Department of Labor audits. And we're covering both federal and state of New Jersey audits because, in fact, both departments of labor do audit businesses. Very often it is the New Jersey Department of Labor, and sometimes it is the Federal Department of Labor, although they cooperate. So you usually do not get labor by both at the same time. In terms of what we're going to cover, it's going to be first the DOL focus. What do they focus on when they come to do audits? Second, the red flags that trigger audits. Third, the steps employees can take when they are given a notice they're going to have an audit and what they should do. The actual audit process and the employer's rights during the audit itself. So, how do you prepare for the audit? Let's start with that. What are they looking for? Out of the blue, you may get a notification that the Department of Labor is coming and would like to audit your workplace. We are on the second slide. Okay. They're looking for improper wage deductions, incorrect classifications of employees as independent contractors, and compliance with certain state processes or policies such as paid sick leave. How far do they go back? If it's the state, they can go back to 6 years. They go back to 6 years of records. And if it's the federal, they usually go back 2 years, but they can go back 3 years if they decide that there's a violation that's willful. In terms of the records itself and going back, the DOL is going to ask you where your records are. If they walk in unannounced, one of the things they will ask you is where are the records? You're supposed to have the records at the place of business or at a central location in the state of New Jersey. Now, in terms of why do they come? Why would the DOL show up at your workplace? Many times, there's really 2 major triggers here. First of all, it can be a complaint. There is a hotline that the Federal Department of Labor has, and employees or workers can call and make a complaint about the employer. They fielded 900,000 calls last year, close to 1 million calls from workers. When a worker files a complaint, it's confidential, but the DOL will take the information, and if they think there's something there, they may well follow up on it. Why would an employee complain? times that I've seen it, it's because there's a dispute. And very often it's a dispute at the end of employment. What happens is somebody, suppose it's an independent contractor, they are let go because there's no further need for them. And they apply for unemployment, and lo and behold, they find out they don't qualify for unemployment because in fact, they were not an employee and no unemployment payments were ever made from their payroll. Unemployment in New Jersey will then get in touch with the employer and start to ask questions that can then trigger a referral to the Department of Labor in New Jersey. And then the Department of Labor is at your doorstep asking all sorts of questions about not just that employee, but all of your employees or workers, especially someone who is in the same classification as the person who complained. Another trigger is that the employer may issue both a W-2 and a 1099 for the same worker for the same year. What does that mean? That means that the worker has had two statuses during the year. They've been an employee and they've been an independent contractor. That can happen when somebody is an employee and is let go and then becomes an independent contractor, but in fact is doing pretty much the same work. Which is a red flag and a problem. The other way it happens, of course, is that business hires someone as a temporary worker. After a few weeks, a month, whatever, decides, you know what, this is working out. We're going to hire this person. So the person ends up getting a W-2 and a 1099 for that year. The other way that you can come across the radar for the DOL is the specific type of industry that you're in. The DOL, both the federal and the state, target certain industries. What kind of industries do they target? They often target industries where they have determined that enforcement of wage and hour laws are lax, that there's traditionally or historically a problem with enforcement. Second of all, vulnerable workers. Their goal is to protect workers. And so there are certain industries that may have an overabundance of undocumented workers or workers that are otherwise being taken advantage of by the business because they don't, they're not employees and they don't have what they need to become employees. So those are the type of industries that the DOL will look at. And you can see it. I've seen it in my practice that restaurants are being targeted, construction firms are being targeted, places that the DOL thinks that there's a problem, they'll go after. We can move to the next slide. Some of the targeted industries that the federal DOL will say these, in fact, they put it right out there. They say these are the industries that we're looking at. Construction, food services, that's restaurants, retail, stores, healthcare, agriculture, temporary help, building services, janitorial, landscaping. Landscaping is a red flag sometimes. Auto and clothes manufacturing. And then there are some sort of niche ones like beauty salons, childcare, hotels and motels. Not surprising when these type of businesses get audited. There were usually also fast growth industries. So for example, the food delivery services, Uber, Lyft, these were industries that, 10 years ago, there were not many industries out there, ride sharing or food delivery, the internet ordering, etc. And they grew astronomically. They also had a independent contractor model. So before long, the DOL was onto it. And they started looking into it. They would send questionnaires to people who received 1099s from those type of industries. And they did very big investigations. Now, how successful is the DOS? Well, the DOL, well, they're pretty successful. The federal DOL, we can move to the next slide, publishes its success rates. And it's usually overtime violations. It's, 88% of the time, the DOL will find an overtime violation. Less frequently, 12% of the time, they'll find a wage violation, that the minimum wage is not being met. So for example, in the restaurant industry, there is a tip credit. And, the DOL will look to see whether the employee is being paid the proper basic tip amount, hourly rate. So if you look at the DOL federally, the minimum wage is different than the state wage in New Jersey. So sometimes you'll have an employer who will pay the federal rate, but not the New Jersey rate. Pretty much in New Jersey, employers realize that the minimum wage has gone up very quickly and where we are. But things like the minimum wage for tipped workers is higher than the federal rate. And so that can be a little bit of a landmine for people if they don't realize that the New Jersey rate is in fact higher than the federal rate. Okay, so I have on the slide some of how much that they have collected, in fact, and it's a lot of money. It's, if you look, it is the average rate is over $1,000, close to $1,400 that employees are getting. Construction, you're looking at close to 33 million. Healthcare, 32.5 million. Food services, 27 million. Building services, close to 10 million. Retail, 7.5, and agriculture, close to 6. This is why the DOL goes after those industries, because they know that there's a lot of violations in there, and it makes their job worthwhile. Where does that money go? It goes to the workers for the most case. How does the DOL fund its services? In addition to paying the workers, if they find violations, they're going to impose penalties. There's fees, there's penalties, and those add up as well. It's not just that you have to pay the workers, you're also going to have to pay the DOL. Both the state and the federal do have their own structure for how they impose fees and penalties. Okay, we can move to the next one. So, how do you find out that you're under audit? Well, really, there's two ways. I think I mentioned it before. First, you can get a letter in the mail. Out of the blue, you get a letter. Sometimes it's a subpoena, and it will say, we are coming on such and such a date, and we need you to have all of these documents ready for us. Now, the other way to do it, for the DOL to do it, is to just knock on your door and say, I'm here, I'm going to audit you. It's a surprise audit. Those are the ones where, you can be completely unprepared, completely overwhelmed, and scared. You should know that you do have some rights. You have a right to ask them to come back at a time that is not so disruptive. You can ask to have an accountant or a lawyer present during the audit, which many employers do. Many businesses will do that because they don't feel comfortable with having somebody there going through their records, especially if it's the first time. It's very intimidating. The auditor can, come in and just say, I want all of these records, put them on the table, I'm going through them. Your records may not even be in order, which from your perspective, you get all ramped up. Oh my gosh, where's this? Where's that? Etc. So you should know that you can ask them to come back and ask them to reschedule. So you've asked them to reschedule. Then what do? You get ready for the audit. How do you get ready for the audit? Well, there are certain steps you can take. Go to the next slide. First of all, as I indicated, you can get in touch with an accountant or an attorney who has experience in handling audits, and they can guide you through the process in the background. They can also, establish contact with the DOL, and many times the DOL is happy to deal with attorneys or accountants because they know that the person on the other side of the phone knows what they're doing. They knows what the steps are. They're not going to be resistant. They're gonna get things perhaps done more smoothly. Sometimes with the state DOL, if an attorney or an accountant is involved, they'll permit the business to do what we call a self-audit. They have sheets that the business can fill out, and they'll take each employee and they'll go through the payroll for a certain amount of time, and it's an honor system. You have to pick out where there may be problems. You note it on the sheet, you calculate what you believe is due, and then you submit it back to the DOL. When that happens, you have more control over it. Not that you're going to misrepresent anything, but you understand how someone was paid. So there's not as much questioning. You or your attorney or your accountant knows the background, knows what perhaps what notations mean, et cetera. So it can be easier and less intimidating in many ways. First thing you want to do when you get the letter and you've said to the DOL, well, you're going to come on such and such a date, you work out the date, is you have to get your records together. Okay. You have to organize them. You have to make sure you have them all. Again, if you keep them somewhere else, you might not have them on site. You got to get them there. You may want to redact the documents. You're not required to give the Department of Labor auditor things like the Social Security number of every worker. You don't have to give them communications that are privileged. Perhaps you've been in contact with an attorney about the audit process or about some wage issues that you have. You can redact that. You don't need to produce that to anybody, much less the auditor from the Department of Labor. You should make copies of all the documents that you're going to let the DOL review. Why is that? You want a clean copy. You want to make sure you have it for your own records. And it's just a good practice for you to have a copy of what you're going to give to them. There may be misfiled records. Sometimes there's been a change in ownership. There's been a change in the bookkeeper, and some of the records are kept differently. They put in storage. If it's New Jersey, it's from 6 years ago, 5 years ago. They might have been put in storage or shipped to another office. You have to get them back. You have to make sure you have what you need, because if you don't have it, it's going to look like it never existed. So you have to look for all the records that are listed on the sheet from the Department of Labor. Some of them are, may surprise you. They're coming in to do a wage and hour audit, but what they're going to ask to see as well are the posters on the walls. Do you have the posters? Do you have a handbook? Do you give out required notices to your employees? Why do they do that? They do it because this is their opportunity to come in and see how compliant an employer is. They just came in and did the wage and hour. Yes, they've achieved that, but they're missing an opportunity to make sure that other laws are being followed. They've shown a real interest recently in the FMLA, the Family and Medical Leave Act, asking employers routinely to show them their policy. One of the things that you should know is that the FMLA only applies to employers that employ over 50 people. So you can get that notice from the DOL and think, oh my gosh, I don't have an FMLA policy. But if you only had 30 employees, you didn't need a policy because it doesn't apply to your business. One of the things, it is intimidating. And as we go through this, one of the messages I want to give you is that many DOL auditors can be helpful. They can explain to you, they can help you come into compliance. They can say, you know what, you gave them these notices, but you really need these notices as well. And many, they're not accusatory, they're just trying to help you become compliant with what the laws are, okay? If it turns out that you do not have the records that you might need, think about how you can fill those gaps, okay? So you can, maybe your payroll company has some records that you just don't have on site. They keep them for a certain amount of time. You should be able to either log in or call them and get some records. Maybe your accountant has the records. You can look for them, have the time to get them calmly without somebody standing over your shoulder saying, where are they? They're supposed to be on site. Now, the other thing you might want to protect is confidential information. Every business is different, in terms of what the confidential information is and where it's kept. So that you do your best to keep that protected. So in other words, if you bring out paper files, you're going to look through them before you give them to the DOL, because you don't necessarily want the DOL to have, perhaps the comparison rates with other people in the industry, whatever you might have mixed in with the record. So those are things that you can clearly take out of the files that you're going to give them. One of the things, if we move on, that the DOL is going to look at, and you have to be prepared about, is the exemption status. Okay, I'm going to get to that in a minute, but I sort of skipped the second page of this. After the documents, we talked about the documents. The next slide shows some other things that you're going to look at, and I've already mentioned some of them. The posting of government mandated posters. Make sure they're where they're supposed to be, which is where a central place where employees can see them. Many people obviously put them in their workroom, their cafeterias or kitchens. Other people put them over the Xerox machine because, inevitably people are at the Xerox machine and they will see the posters. I-9 work authorizations. Again, this is an opportunity for the Department of Labor to come in and check lots of things. And one of the things they may check are I-9 records, which the employer has to keep. And so this isn't, a seminar on the I-9 requirements. It's just warning you that that's something that you really need to have in order if you get a notice of an audit. Personnel policies and forms. Why is that important? That's important because you may need to explain to the auditor why things are done a certain way. So for timekeeping, you may have a login on the computer that people have to log in by such and such a time. You may have a policy that people are entitled to take a break at such and such a time, and hopefully you have a policy that says during a meal break, the employees are not allowed to work, that they are to take their break so that you don't get into problems with overtime because people are actually sitting at their desk eating and answering the phone. So, having those policies there, having them ready for the auditor can be very helpful for you, both in answering questions, but also in showing the auditor that there's really no problem there. Now, create a system for the audit. You want to be ready before they come in terms of who is going to talk to the auditors. Where are you going to set them up? Are you going to have the auditor in the front, in the reception area? No, you're going to find an office or a meeting room where the auditor can sit there with the boxes of records or a computer, if they're computerized, whatever the auditor needs. You want to give them the space to do it. It also gives you and any management employees who are going to talk to the auditor privacy. There's a separate area that they can talk to the auditor, they can have the questions asked without other people hearing what is asked and what the what the results are, what the answers are. Daily debriefings. Now, sometimes an audit only takes a day. So, you have the meeting at the end of the audit. Sometimes the auditor is there for a week. In that case, you really want to set up a schedule. You want to say to the auditor when they come in, what time do you expect to be here until? Can we plan to meet 20 minutes before you leave? Why do you want to do that? You want to have an open channel of communication with the auditor. You don't want the auditor to think they're finding something and you don't know about it, and you have records or evidence that you can give the auditor that will take care of whether any concern they have with respect to a potential violation. But if you don't talk to the auditor from the time they arrive until they leave 4 days later, you're not going to know that there is a potential problem, and that you can talk to the auditor and get the information about what they're concerned about and respond to that information. And most of the time, the auditors are receptive. They're there to do a job, but you're the person who knows the business, and you're the person who knows what records you have and what the practices of the business are. So you can clear up uncertainty if you have a daily debriefing and you talk to the auditor. Okay. Now, next slide. The next thing you want to do is prepare your employees for the audit itself. By saying prepare your employees, I don't mean coach them. I don't mean give them a written document that says you must say X, Y, and Z. Not a good thing to do, because you don't want to coach them. You don't want to give them information that's not accurate to convey, because that would be a huge problem. What you do want to do is remind them of policies. Make sure they know how to answer questions with what is truly the policy at your workplace. So, job titles. What are the job titles of the different classification of workers in your business? Are they exempt or non-exempt? If they're exempt, if a job title is exempt, you want the manager to be able to explain why it's exempt. You can't have somebody say, well, they're on a salary and that's why they're exempt. Many employers tend to think that way. It's not accurate. It's not how either the state or federal exemptions work. The primary ones are executive, administrative, and professional exemptions. And there are criteria for each of them. Yes, salary basis is definitely one of the criteria. And in fact, the Supreme Court of the United States recently ruled in a case involving an exemption and the salary requirement. Turned out in that case, the employees who were, frankly, meeting the other criteria were paid a daily rate. Okay, so maybe they were paid $300 a day or $400 a day. They're paid $400 a day. They're getting $2,000 a week. They're getting $100,000 a year. That meets the salary requirement. But because it was kept or paid as a daily rate, a day rate, the Supreme Court held that it did not meet the salary requirement under the under the FLSA standards. So one of the things, if the auditor wants to know about exempt employees, you have to know about how much they're paid, because there is a floor for salaried employees. If it's a highly compensated employee, it's just the fact that they are highly compensated. They're paid close to $108,000, $109,000 a year. Once they get over that and are doing certain kinds of work, they are exempt. When you talk about executive exemption, the auditor may ask, or do you, employee, termed an executive employee, what do you do about personnel decisions? Do you have input in them? Do you have the power to hire and fire? What is your role? Those are the type of tests that establish exemption versus non-exempt jobs. And so the auditor is going to want to know that if you have exempt workers, and by that we mean exempt from overtime, that they're really not due overtime, that they direct a certain number of employees, that they have the power to hire and fire employees, that they exercise discretion and independent judgment. You want to go over those things with whoever's going to be talking to the DOL auditor to remind them of why somebody is exempt, why they are classified as exempt and not paid overtime. Because people don't think about that in their day-to-day work. They're doing their job. They don't think, oh, I do exercise discretion, and oh, I do supervise, 2 full-time workers. You have to remind them of why they do fit the exemptions for overtime work. They may want to know how time is reported. That is something that's really important to the DOL. They want to make sure the time is being recorded so that if there's overtime for non-exempt workers, that overtime is being caught. Okay. Now, today in this world, it's easier for employees to keep their time. If they're on a computer, many times there are systems where you log in, that's your time record. You log out when they're taking a break, they log out at the end of the day. If the workers are out on the road, there are handheld on their phone ways to log in to track their hours. It's easier than it's ever been to track hours. In New Jersey, for example, you don't have to have a time clock. You really don't. If everybody comes in at 9 o'clock and they take an hour lunch and they leave at 5 o'clock and the doors are locked and they can't remote in and it is the standard, it's acceptable for the employer not to have a time clock. That being said, it is probably safer if you're trying to prove that you kept the hours and that nobody worked overtime if you have something in black and white on documentation that people did not go over 40 hours a week. And as I hope 40 hours is 40 hours. So if you are giving people a full hour of lunch and they are not doing any work, you don't count that hour towards the 40 hours a week. If somebody has been out sick, taken a vacation day, there's a holiday, that day doesn't count. It has to be hours actually worked. The other thing that the auditor may look for is how employees are paid in terms of their weekly or biweekly pay. It's becoming less common, but for many years, you would look at the paycheck. It would be for a 2-week period. And as long as it didn't go over 80 hours, the employer and sometimes even the payroll company would say, okay, no overtime owed. However, if it was 30 hours in one week and 50 hours in the other week, overtime is in fact owed on the second week because the DOL looks at it 1 week standing alone in and of itself. They don't combine weeks to say this is a payroll period, and as long as you don't go over 80, you're home free. No, they're going to look and say, well, in this week, they worked 43 hours, and in this week, they worked 38 hours. Did you pay them overtime in the week they worked 43 hours? And if you didn't, and they're going to, find that's a violation, they're going to look at everybody else for all of those weeks to figure out if there are violations. Okay. Bonuses. How are your bonuses calculated and paid? Are they discretionary? Are people entitled to them if they hit a certain number of hours or productivity? This is important because it may factor into what the hourly rate is if there is overtime. That's the other thing about overtime that a lot of times employers might not realize is that it's not always that a person is paid $20 an hour or $15 an hour. So if they go over 40 hours, it's an additional $7.50. If there are different things that happen during the week, the DOL will come up with an hourly rate for that week. It's every week standing alone. So in some ways that can help you. If somebody worked 45 hours in a week and you paid them $1,000 because that's what you paid for a regular week of 40 hours, what would happen is the DOL would say, okay, they actually worked 45 hours, they were paid $1,000, and therefore let's figure out what the hourly rate is, and I don't know if I can do it in my head, maybe 50 hours is better. They worked 50 hours and they were paid $1,000. And so it came out to $20 an hour. So for the 5 or 10 extra hours, you're going to owe $10 an hour, which might be less than the hourly rate on the 40 that you thought you were paying them. Okay, if that makes sense. It's a constant calculation, and every week can be different. It can be it's exhausting sometimes to figure that out if you have to do it on a daily basis. When I say be prepared with the documentation, for example, if you have a login and a log out automatic, people do a time clock, or they do a computer login. What happens if they forgot to log out? You may have a situation where it looks like they work 24 hours a day. One of the things that you might want to make sure is in your system is that at a certain point, the machine or the program automatically logs people out. So if the business usually closes at 6 o'clock and 99% of the people have logged out at 6 o'clock, but 1 or 2 people forgot. If you have an automatic log out by the program at 9 p.m. or 8 p.m., first of all, it will log the people out at that time. So you're not going through the night until the next morning when they come in and say, oh my gosh, I forgot to log out last night. Second of all, if they, it's a routine, 5 people logged out at exactly 9 o'clock p.m., you'll be able to argue to the auditor, look, it's clear that they just forgot to log out, because that, in fact, 9 o'clock is in fact the time that the system automatically logs people out if they forgot to do it themselves. So there's things you can think about in terms of, how the records are kept and what will show over time, and what, in fact, if you have your ducks in order, you can show the auditor was not overtime. Okay, now, some of the things or areas that employers don't think about, they're just getting their regular, weekly wage records in order, is other periods of time. Training. What is your practice with respect to training? So, for example, if you are in an industry where you can pay a lower hourly rate because, for example, there are tips. You get tipped workers and you only have to pay them, X $5 something an hour in New Jersey and $2 something in the federal system. And these tip workers have started to work. You have a whole new slate of servers in a restaurant. But you have them come in for training. You can't just pay them that rate during the weeks that they are in training because they're not getting the tips. So they're not meeting the minimum wage. So you want to have it set up so that you are in fact paying them the minimum wage during the training, and you can prove that to the auditor that you haven't cut any corners with respect to training time. Traveling, orientation, all of these sort of sectors of work or periods of work have special rules under the FLSA and the New Jersey Wage and Hour Law. And I don't want to go off track, but it's something you should be thinking about. If your employees, have to fly somewhere, are you paying them for that time? There's very particular rules about what you pay for and what you don't pay for. Of course, if they're exempt, you don't have to worry about that. But if they're not exempt, it's something you need to think about. Okay. And they will ask you if it looks like people are on the road a lot, they may ask you to see what your policy is with respect to travel time. Okay. Now, one of the other, so this section was really on how do you prepare your key employees to talk to the DOL. These are the type of areas you want to cover with them so that they're not floundering, so that the auditor doesn't put words in their mouth and just say, oh, so you don't have a policy on this. So you're telling me that there are no, people don't get paid for X, Y, and Z. Just remind the, your management team what the policies are and why they are that way, why they meet the DOL requirements. You also have to prep them in terms of what the DOL rights are. What's the right of an auditor when they come into your workplace? You want your workers, your management team to know what the DOL auditors can and cannot do. And we're going to cover that, okay? We'll cover it a little later on. So now we're going to talk about what actually happens. You've done your preparation. You've made sure your posters are up. You've gotten your FMLA policy, your paid sick leave policy. You've talked to your management employees. You've reminded them, why people are exempt, what the practices are for timekeeping, what the practices are for paying, etc. You're ready. You've done your prep work. Now the DOL auditor arrives. We can move on to the next slide. One of the first things they're going to do is they're going to tell you how long they're going to be there, how long they anticipate it, and what documents they need. Most of the time, you already know what documents they need because you've gotten the subpoena or letter and you've gathered them. When the auditor comes in, there are certain things that you should do as the business owner or the person who is designated as the management employee to deal with the auditor. First of all, you're allowed to verify their credentials. The DOL auditor will have an official identification, so they are who they say they are. That can be really important if it's a surprise visit. Somebody walks in the door and says they're a DOL auditor. You really want to make sure that that's what they are. As I said before, you can request that it be done at reasonable times and not interfere with the work going on in the business. When do you say an auditor is interfering? When are they interfering? When are they not interfering? Because of course they're there to look at records. They're there to perhaps talk to employees. When does it cross over the line? One of the things we tell clients is that if they're talking to individual employees, say they're walking through an office area and they are stopping to talk to each employee for 10 minutes or 15 minutes, that's disruptive. Not only are they taking that person away from the work they have to do, but they're, while they're doing that, everybody else in that office, in their cubby holes or wherever they are, may not be able to do their work either. So something like that, you could say to the auditor or the management employee dealing with them could say to them, can we arrange a better way to do this? Not on work time, perhaps. Now, You want to introduce your management team to the auditor. You want them to say, this is who we have ready to talk to you and provide information. Here's the room you're going to, we're going to have you work in. Here is that person's extension if you want to get in touch with them. You want to make it as smooth as possible. And you want to be polite, you want to be cooperative, you want to be respectful, because the worst thing that can happen is to be defensive, to be sort of flippant or nasty. Anything like that is gonna get the whole audit off to a bad start, and the auditor's going to get defensive himself and become offensive. And you're in a much better position if you established a cooperative communication system with the auditor from the very beginning. That old phrase, you get more with honey than vinegar, is very true in lots of ways and places. And it's true here. When you have somebody come in to look at your records, you want to be cooperative. You don't want to be challenging to them. Okay, we'll move on to the next one. Now, what do you do with the documents that you've gathered and the auditor is looking at? Well, first of all, do not allow them to take the original records. Those are your records, okay? That's why one of the reasons you have a copy, you may want to give the auditor copies if they're going to work off-site. They may ask for that. They may ask you, sometimes now they'll say, we want everything in electronic form. And you have to actually give it to the investigator in electronic form. Actually, that's more common than not, especially with the federal DOL. You're not going to let them take the original documents. You're going to give them what they need to work with, but you're going to keep your own documents. Don't create new documents. That you're supposed to be showing them what you have. Don't try to clean it up by creating new documents, because there's a risk that will be discovered. You mean you didn't keep these contemporaneous time records? When did you do them? You did them last week? That would be a problem, because you're not complying with the subpoena or the request for the original contemporaneous time records. This is a theme in general. Don't give more than you're asked for. Don't give so many documents that you're giving the DOL records that they never asked for. So for example, if it's a federal auditor and they've asked for 2 years of records, don't just give them 4 years of records or 5 years of records. You're inviting them to go back farther than they can in terms of looking at your timekeeping practices and payroll. And you're making it take longer and be harder. It's true with respect to documents. It's also true with respect to information. A caveat, of course, is that if the auditor identifies something that's a problem, you may need to correct a misunderstanding and say, well, that's not really true because X, Y, and Z. My example with respect to the automatic logout for timekeeping is something that would, be something that addresses that. So, for example, you might not automatically give them all the information you have on the automatic logout, what the program is, how it works, etc. But if the auditor starts calculating overtime for all these people that forgot to check out or log out at the end of the day, that's when you're going to want to volunteer information and say, oh, wait a second, we have this automatic logout system, and this is how it works, and this is how it's programmed, and this is how we know that they forgot to log out. Okay, so that's an example of a time when you are going to offer some information or some documentation. If you have questions and you really don't know, should I do this? Should I tell them this? It's always good to have an attorney in the background who you can call either during the day or at the end of the day and say, this came up, I need to know what I should do about it. There's nothing wrong with doing that. You don't have to tell the auditor. You don't have to, and you shouldn't actually tell them whatever you were advised by the attorney. You should, obviously take the attorney's advice and give the DOL what's proper to give them. Okay. Now, we can go on to the next page. After the DOL comes through and you set up the structure for the audit, that, they'll tell you how long they expect to be there. They'll tell you what records they want, and you'll have gathered them. You've set aside a place for them. They're going to be, you say, this is where you're going to be working. They might put their briefcase there, etc. They're going to want to walk through the business. They're going to want to understand what the business is, what types of jobs there are, what types of employees you have. It gives them a grounding. So they should be accompanied for sure. I think most people would know that they can't let the auditor just wander unaccompanied through the work site. You're going to want someone responsible, a management representative, to be with them. I have a little note here, unless it's a private interview with an employee, that is separate. And I have hourly employee, really should say non-exempt employee. I thought I changed that, but anyway, that the investigator or auditor can ask for privacy with respect to, and the management employee is not allowed to be in that meeting, but we'll get to that. You want to make sure, as I mentioned before, that this doesn't become a huge to-do in and of itself. The management employees walking the auditor through the business, and there's a big announcement and everybody stops and there's 20 minutes of people milling around. It's not good from your perspective. It's also not good for the auditor. They want to see how things work there. They don't want all operations to cease as soon as they walk in the room. It's going to extend the time that they're there. And again, you may end up giving information that was not requested. And so you want to be careful about what you do. I mean, how long and how much of a production you make that. Take notes of everything. You're entitled to do that. Tell whoever's accompanying them that they can take notes. It's everything that's said. Who did they talk to? What kind of topics were they interested in? What did the investigator write down? What did they seem really interested in? Because sometimes it's just a check off. Okay, they're complying with that. But if they're furiously scribbling about something, that may well be a tip off that they think there's a problem. And that's something that you want to get, that night, talk to the person who accompanied them and took the notes, say exactly what happened, and think about ways that you can, again, get your ducks in order and let the auditor know that there's really not a problem. Any comments, obviously, you want to know about. You want to know if the investigator said, this looks like a problem, or, oh, I get it, this isn't a problem because X, Y, and Z. So everything that is going on as the investigator walks you the work site, you want to know about, okay? Now, next slide, employee interviews. That is something that the auditor, the DOL investigator, is absolutely entitled to do. They are entitled to talk to employees. Private life, you are not, as a member of management, allowed to demand that you be present. These are lower level employees. There's different rules with respect to high level employees. So you want to schedule them as a convenient time. In other words, have it in the little workplace, in the office that you've set aside, not in the middle of the work floor, not in the middle of the day. Whenever there's a good time that won't disrupt operations is really when you want to schedule it too. Many times the investigator will ask for information, contact information for employees, which you do have to give them. They'll ask for the telephone numbers, they may ask for emails, and what the investigator will do is actually contact the employees on the side. Why do they do that? Because employees might feel more willing to convey information if they're not in the workplace. Whether true or not, an employee can feel like the owner, the employee, the employer's management is looking over their shoulders and they better be careful. The investigators know that, so they may well want information to contact them on the side. What are the topics that they ask them about? All the things that you tried to become prepared for. What are their hours of work? When do they clock in and clock out? Are they doing work off the clock? Are they, being asked to come in and do 15 minutes of prep before they even clock in? That is not something that should be going on in most cases. And if the worker tells the DOL investigator that, you can be sure it's something they're going to follow up on. Again, they're going to ask about what their duties are. They're going to, make a determination, or at least an initial one, as to whether this employee is exempt or non-exempt, and make sure that that's how they're being paid. Now, what can you you do to prepare your workers for this meeting? Well, you can talk to them beforehand, okay? You just so there's some fine lines you don't want to cross. You can speak to them prior to the interviews. We can move on to the next slide. You can inform them that it's voluntary and that they don't have to talk to the investigator. What you should not do is convey to the employee that you don't want them to talk to the investigator, because that could be considered coercive, okay? So it's their own choice, it's voluntary, but do not convey that you don't want them to do it. You can remind them of the policies in place. You can remind them that at lunchtime, the rule is that they don't take phone calls, that they are relieved of all duties. You can remind them that, the rounding practice is that if it's 2 minutes over the hour, it doesn't go into overtime. You can remind them if it's 3 minutes under the hour, it doesn't get counted, that you round to the nearest, say 15 minutes or whatever. You can remind them of what the policies are, just to make sure that they're accurately conveying information. But again, what you do not want to do is coach the employees or tell them to give specific answers. The reason is, first of all, it looks like you're coercing the employees. Second of all, it can sound really, it can be a red flag. If everybody's giving the exact same answer and the exact same words, the investigators are not stupid. They're going to know they were told to say those things. And that would be a problem in and of itself. So you don't want to really coach them. You don't want to pressure them in any way at all. Okay. So the do nots are right there on the slide. Do not coach them. Do not pressure them one way or the other. If somebody's reluctant and doesn't want to meet with the investigator, fine. They don't meet with the investigator. Don't pressure them to do them, and especially don't pressure them not to meet with the investigator. And finally, don't retaliate. What will happen is, you may know. If the investigator comes up with a violation that was not apparent from the records, and that they only spoke to 3 employees out of 36 employees, you have a good sense of who may have told the investigator what the background information is and how things are gone. At that point, it's when you have to start treating that employee well. You don't want any claim that you retaliated against the employee or treated them differently or gave them a worse assignment or cut their hours or did anything because you thought they told the DOL investigator something about how the business was run. Okay. So you want to tell the employees, give the employees some tips. You want to tell them, always tell the truth. You can tell them that. You can tell them, listen to the question and answer the question. Don't guess. Tell them the information that you know. You stick to the facts. Don't speculate about what the practices are unless you know what the practices are. It's okay if the investigator asks you something and you don't know the answer, it's okay to say, I don't know the answer to that. I don't really, that hasn't come up, or I really don't know as I sit here what it is. And don't, you can tell the employees, make sure what you're saying is accurate. And part of that is don't let the investigator put the words in your mouth. Don't let them suggest what the answer is and just nod your head and say yes if that's not the case. They also do not have to sign a statement that the DOL investigator prepares. They have a right not to do that. They have a right to see documents if they're being questioned on documents. They have a right not to have the interview, to say, I don't want the interview recorded, either audio or video. They also have a right to have somebody with them if they want somebody with them, say a union rep or another employee. They can ask for that. Again, however, you're not going to encourage your employees to do one thing or another. If you're preparing them, you just want to let them know the lay of the land. You don't want them to point them in one direction or the other. Sometimes it's helpful to have an attorney prep them. It's similar to when we prep people for their depositions and litigation. There's lots of attorneys have more experience in what in fact they might ask and what's speculation and what's not speculation. So for example, if somebody asks the employee, I don't know, did you go out to lunch that day? And the employee might say, the answer is yes or no. The employee might say, oh yeah, we drove to such and such diner this far away, blah, 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 blah. That's offering information. Again, you're not going to forbid employees to do that, but it helps them if somebody is preparing them in a way that they sort of recognize then what the auditor or the investigator can properly do with them and ask them and do in that interview and what they can't do. Okay. Okay, now we can go to the next slide. Now, the management employee interviews are different because if it's a management employee, if it's your director of operations or a vice president and they are the ones being interviewed, everything they say binds the company. The auditor is going to take what they say as the gospel truth and count it as the policy of the business. Now, they can make mistakes too, and you may be able to correct that, but because they're a member of management, they are treated, what they say is treated more carefully. They can have somebody else attend who's in management because they are binding the company, and they can even have a lawyer present if they want. If they can request that they have one, and the investigator would have to say, yes, your attorney can sit in on this interview. Now, if you have somebody else there, or even the person themselves, they can take notes. They can write down exactly what the auditor is asking about. And the auditor, it may become it's a give and take sometime. Like, the management employee may explain something. I'm going to go back to the example about the automatic clock out. They can say, oh, this is what we have. And then the auditor will say, oh, do you have any documentation about how that works? So of course, the person is going to be taking down notes and saying, however they do it, little arrow, make sure to get them this, make sure to get them that, look into this. Have the person take notes because it tells you where the investigator is going. And it also gives you the opportunity to present extra information or documents in those places where you need to clarify or a violation is going to be found. Okay, but even though they're management and even though they're going to bind you, you again do not want to pressure them, coach them in a way that suggests that they're being given canned answers, and especially not suggest to them that anything that is not true should be conveyed, or anything that they're supposed to give to the investigator should be concealed. We always go back to the Al Capone example. The cover up or the attempt to manipulate a process always ends up causing more trouble and problems than whatever the initial problem or violation may have been. So again, across the board, you're not going to be coaching or pressuring anybody when you prepare them to meet with the investigator. Okay, now, the daily debriefings. We've talked about how that can be important. And so we can go on to the next slide. A daily debriefing is when you're going to sit, whoever your designated person is to deal with the auditor is going to sit and meet with the auditor or investigator at the end of the day and go over what the investigator found. They will often say, the investigator will say, okay, this is what we found. We're interested in this. Okay, maybe we're interested in your rounding policies, or maybe we're interested in whether these employees are really exempt or not. Okay, that gives you the opportunity to think to yourself, okay, I have to come up and show them why we made a good faith determination that this employee is exempt. Okay, so even though they don't supervise 2 full-time employees, they supervise 8 part-time employees, and when you add it up, it adds up to the necessary 2. It gives you an opportunity during the course of the audit to make sure that the auditor understands what's really going on in your business. Okay. Also, they'll give you often just a time period. They'll say, we'll be here one more day. Tomorrow's the last day. Thursday's the last day. We're going to do the wrap up. We'd like to set up a meeting, for 2:30 on Thursday afternoon. It's a roadmap. And so it's very helpful for you, and it's helpful for the investigator themselves. Okay. So then you get to, next slide, we get to the actual wrap-up meeting. I do want to say something on the side here. I'm giving you an example of when the investigator comes and does the entire audit on site. That may not happen now. And especially since the pandemic, a lot of auditing and investigations were done remotely. So the investigator would say, I need you to email me all this documentation. Okay, I want all the payroll records. I want all the time records. I want them in Excel searchable format. I want all the names of the employees and what their job functions are and what their telephone numbers are. They may do most of this off-site. They may have initially come, they may have initially walked through the operations, but they may do a lot of the investigations off-site. In that case, then, I mean, it's fair enough for you to say, to write to them or to call them if they give you their number and say, can we have a check-in? They might not do it every day that week. The investigator may take all your information and they're working on 10 investigations. And they might not finish looking at your time records for 2 or 3 weeks. But what you might do is say to the investigator, when you're done the preliminary review of the time and hour records, can we have a debriefing? Can we schedule a call so we know where you are and we know what you may be looking for? You can do that if it's a remote audit, okay? Same thing with the audit wrap-up. You have the audit wrap-up. If it's in person, it's going to be in your office. If it's remote, it's going to be a Zoom call, something like that. And what does the auditor do? It's a give and take, really. The auditor is going to let you know what they found, okay? If they're going to find that you have violations, they're required to have this conference. They're required to tell you what they plan to do and make sure there's not other information that's out there that could, change the result. So they will present to you. They'll say, okay, based on our investigation, we found that, 18 employees are owed overtime, and this is who they are. It's such and such. These are the number of hours. This is the rate that we found. This is the full amount that's owed. And they'll go through, they'll have it written out, and they'll let you know that. They'll explain if they found other violations, if they found violations, say, in rounding up, if they found violations in clocking in and out, if they found, for example, a violation in calling somebody exempt or classifying them as exempt when they're not exempt, they will let you know that. And they also, they see this as part of their job, and it is part of their job to explain to you what is wrong and why it's wrong and how you can correct it. And sometimes what they'll do is they'll say, I didn't find a violation here, but I want to make sure that you understand X, Y, and Z. Okay. They want to make sure that they're conveying what the regulations are and that you're set up to be compliant going forward. Even if you are compliant, they're just going to remind you of certain things. And they also are going to explain your post-audit right, which means you can challenge things, etc. Sometimes, however, during this wrap-up, there are things that you can do and say that can delay the final determination. Okay, what should you do? We can go to the next slide. When you're sitting there with the investigation and what is often the final meeting, you should take notes and you should write down exactly what they're saying so that you understand what they found and why they found it. Okay. Be very careful. Some people are very agreeable and they'll just say, yes, yes, yes. Oh, I get it. Blah, 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 blah. Be quiet. Don't say anything. You don't know if when you talk to your attorney later, the attorney's going to tell you that what the auditor did or what the investigator found is really not proper or accurate. So you don't want the investigator to say, oh, but they agreed with me. It was an admission. They agreed with me. You can ask questions you want to understand, but you don't want to say, oh, yes, you're right. I get it. We've been doing it all wrong here, because that can come back to haunt you, and it can also limit your ability to challenge what may be improper determinations by the investigator. If there are violations, make sure you understand why they found a violation and what the legal basis is it for. basis for it is. So, for example, I mean, if they find that you should be paying people for travel time, but the person is actually never reports to the main building, they're on the road all the time, and you start counting from their first appointment, make sure that they tell you why they're finding a violation. This is something you're going to want to present to your attorney or whoever's guiding you to solicit advice as to whether the violation is really a violation at all. Make sure you understand exactly what they're saying the back wages are, okay? You know, it can be, all this information can be thrown at you or your management employee. You might not understand exactly what happened. Make sure you understand exactly what they're saying is owed and why it's owed, okay? You should definitely, if you're completely, you know, confused, or really think that the determinations are way out of proportion to what it should be, you should ask for time. You should say, I really need time to process this, and I need time to provide you with additional information and documentation so I can show you that, you know, we don't think this is accurate or whatever. You're not going to, you know, volunteer information, obviously, but you are going to convey that you believe that there's additional documentation and information that is relevant and could change the determination. Okay. Don't agree to a settlement. Don't sign anything there that says I acknowledge these wages are due, because that's going to be binding in most cases, and it's an admission of liability. And it's not just the wages. They could easily come back and assess liquidated damages, which is, you know, twice what the wages are for each employee. They could do administrative penalties. They could do all sorts of things. You should not agree to the findings right then and there. You really should say, I need time to look at this. I need to discuss it with my attorney or my accountant, whatever it is. You, of course, if they say to you, hey, clean slate, you're going to say, great, please, you know, I'll sign anything, goodbye, get them out of there. But that often doesn't happen. Again, from the beginning to the end, you want to convey that you are cooperative and that you want to be in compliance with whatever the regulations are. And, you know, that's part of understanding what the investigator found. It's, you know, by saying, explain this to me again. I want to make sure I have it. I want to make sure that we're compliant. I want to make sure I get, you know, the additional information that we have. That's showing that you want to be compliant and you want to do what's right. And that can affect the investigator. They can say, this is somebody who is not resisting, is not challenging. They're acting in good faith, you know, and I want to help them get there. Okay. If you think there's additional information, you can say, I'd like a follow-up conference, and the investigation will set one up. Okay. They're not going to give you a ton of time. They're not going to say, okay, we'll meet in 3 months or 6 months. But if you need a week, if you need 10 days, you should ask for it. Again, if they are, final thing is, if you're one of the very lucky businesses and there's no violations, you want to get them on their way, but you want it in writing that there's no violations so that they can't come back a month from now and say, oh, by the way, we realized that something that we found was not a violation is actually a violation. So that's really the end of the presentation. I don't know if there are any questions that people have.
Thanks, Marianne. There are some questions in the chat. Are you able to see them? I know you're partially on your phone, because I can read them for you.
I don't see any questions.
Okay, why don't I read them in the chat? There's some in the chat, if that's okay.
Sure. Let me just see who can see the transcript. Okay. I don't see anything. Okay, go ahead.
Okay, all right, I'll do it for you. Heather White writes, we pay all employees a salary, even non-exempt employees. The non-exempt employees enter time off and overtime in ADP. Is it required in New Jersey for non-exempt employees to clock in and out?
Okay, so it is not required that they clock in and out, but it is required that you keep their time. So, for example, as I said, if your business is only is open from 9 to 5, and for example, you have a automatic lock on the door that everybody's got to be out and they can't work remotely, all you need to do is keep track of when they're not there. if they leave for an appointment, maybe it's an email, maybe you require them to say when they want to request some time off to send an email, then that becomes a documentation of when they worked and didn't work.
Okay, great. Thank you. Next question. We don't have paper files. We are all digital. What do we do to prep if audited?
What do you do to prep for the audit? You go over your digital files just like you would go over your paper files. And again, as I said, the investigator now pretty much want digital files. They want them in a searchable format so that it makes it easier for them, so they can sort, etc. But you should be able, even if it's electronic, to look at it and determine. And again, you're going to focus on your non-exempt employees. You're going to focus on what the clock in, clock out times have, if that's what it is, what they're being paid, whether the overtime is tracked. You should review them. And frankly, if you're a very big company, you have a lot of employees, that's something that the supervisors should be doing routinely to make sure that there is no overtime owed, so that when it comes time and you're audited, you can rely on the fact that the people did it correctly, and you don't have to go over 300 people's time clock records for 2 years or 3 years or whatever it is.
Okay, great. Can the DOL request to review bank records or tax records?
They often ask for them. And you if they ask for bank records, you have to, I would say in that case, consult with an attorney, but in most cases they are entitled to them. They're entitled to, say, the W-2s for employees, 1099s, they're entitled to whatever tax returns, because it's a subpoena. In most cases, when they send you a letter, it's really a subpoena.
Mm-hmm.
And if you're going to challenge it, there's steps you have to take to challenge it.
Okay, and bank records as well?
Yeah,
okay.
Yeah.
Okay. We have timekeeping software that encounters problems when technicians travel through different time zones. We ask the employees to record their hours and confirm with us upon return. We enter it into the software. Do you anticipate an issue with that? Anything we should monitor?
I don't. I think that that's actually very good that they're taking proactive steps. I think that you should, however, ask your employees, either get a copy of what they did to track their time, or I would get a copy and keep it somewhere so that you know that you can back up what you entered at the end of the day when they return from the trip.
Okay, great. NJDOL showed up at our factory. I was not on site, but we were issued a violation for not allowing entry and access to our records. I thought we were allowed to request a reschedule, which we did.
You are allowed to ask for a reschedule. If they turned up unannounced, that's an intimidation tactic to give you a violation for not letting them in. And that is, of course, something that you would want to challenge, get an attorney to challenge it and sort of reestablish the footing that, it was not a convenient time. Nobody was there, etc. And if you have an attorney that you talk to, they'll talk to the DOL investigator and try to reestablish the equilibrium, have them come another time, withdraw the violation, etc. Start off on a better foot.
Okay, great. That's the questions in the chat. We have a few more minutes. If anyone has any additional questions, just feel free to unmute yourself. Okay. Well, with that, I want to thank Marianne Tolomeo from Connell, Foley. This is a lot of great information. You will be receiving the presentation via email early next week, so be on the lookout for that. And want to thank you guys for hanging in with us this morning on a late start, but hope this was valuable information to you. And thanks again for joining us. I'm Alice Gens from NJBIA and for Marianne Tolomeo from Connell, Foley. Nice seeing you all and have a great day.
Thank you.
Thank you.